Hello and welcome to the Arise interview. 60 minutes of big questions about the big stories from the news and beyond, with fresh insight and critical analysis. I'm Charles Anyegolu. Coming up in the next hour, a landmark ruling and a hugely controversial one by the Nigerian Supreme Court. It's dismissed the petition filed by Emeka Ihedioha, the immediate past governor of the southeastern state of Imo, who had asked for a review of the Supreme Court decision that ousted him. It's a judgment that will not be universally welcomed and is likely to further divide Imo State and the rest of Nigeria along political lines. We'll bring you all the news, reaction and analysis in a moment. Now, it's one of the most fiercely and closely fought legal battles over election results ever in Nigeria, and it was left to the Supreme Court to cast the final irreversible decision, with both Emeka Ihedioha and Hope Uzodinma needing a favourable verdict to claim the governorship crown in Imo State. But now the decision is in and the status quo remains, with the Supreme Court dismissing the application for a review of its decision to sack the former governor of Imo State, Emeka Ihedioha, and declaring Hope Uzodinma the winner of the ballot. The judgment was split 6-1, with the majority of justices led by the Chief Justice Tanko Mohammed ruling that the court lacks the jurisdiction to sit on appeal over its own judgment and that Mr. Ihedioha's petition lacked merit and was therefore summarily dismissed. Needless to say, supporters of Mr. Ihedioha are appalled by the court's decision, while those aligned with Mr. Uzodinma are elated. Here's some reaction outside the court immediately after the judgment was delivered.
They have affirmed an unjust judgment. They have affirmed a judgment that delivered injustice, and they have sealed the injustice. What they have done now is a confirmation of injustice. This injustice will live for the next 4 years, unmitigated. This injustice, no more remedy for the next 4 years. This injustice will haunt the entire electoral system. As the Honorable Supreme Court Justice that delivered the dissenting judgment said, they have killed democracy in Imo State and they have killed democracy in Nigeria, and will continue to haunt all of us for as long as we continue to practice democracy in Nigeria. I am ashamed on their behalf. If they are not ashamed, I am ashamed on their behalf.
And that's obviously a lawyer who is there in support of Emeka Ihedioha's cause. Well, in a moment, we'll hear reaction from various analysts to this Supreme Court decision. But first, to dissect the legal aspects and implications of this development, I'm joined now in the studio by Barrister Kashmir Igwe, Managing Partner at Igwe and Igwe Attorneys. Thank you very much indeed for coming in. First of all, your reaction to this judgment.
Well, my reaction will not be different from what is expected of every legal practitioner and every citizen of this country. And what is that expectation? That Supreme Court's decision is final. Being the apex court of this nation, as provided in our Constitution, and for us as lawyers, as litigants, as citizens, we must obey and abide by the decision of the Supreme Court.
Yeah, but that's not the question, though. The issue is that we're trying to analyze that decision. Yeah. Beyond the fact that obviously we're all bound by the law to abide by that verdict. I mean, nobody can change it. It's irreversible. It's the end of the road for Emeka Ihedioha. But in terms of your legal analysis of the way that, first of all, the issues that were before the court, and whether or not this was something that the court could have had wiggle room to sort of, go the other way and perhaps see it in favor of Emeka Ihedioha. What is your legal analysis?
I understand and I appreciate the question and the issues. For me, law is dynamic. You can't, one of my lawyers will tell you that you can't pigeonhole it. It could go either way. It depends on the prevailing circumstance at the time. It also depends on the intention of learned justices. But for me, looking at this judgment, I will more or less agree with the Supreme Court. Not because I like the judgment, but because we need to safeguard our jurisprudence.
So in other words, there were mitigating considerations beyond just the facts of the case.
Exactly, sir, exactly. And if you look at it, the thing played out in the dissenting judgment of Justice Weze. If you look at that, he just came out on what it ought to be, just to reinstate the fact that, yes, we made a mistake. I'm courageous enough to admit our mistake and to let us do the needful. But for me, and looking at tomorrow, knowing that this is a political case, it will rather destabilize our democracy. It will set a very bad precedent.
Right. But also, is it your sense that it would have cast the Supreme Court in a bad light, in a questionable light, where it's supposed to be seen as the final objective arbiter of the law? That it might have put it in a light that would make people lose confidence in the Supreme Court?
Definitely. If they didn't do what they did to stamp their finality, it would have, one, exposed them to ridicule, two, it was eroded public confidence in our judiciary, and three, despite what they did as per Bayelsa case, it has still opened the floodgate for everybody to come for review. And for me personally, I've always told people that I don't expect anything different from what they have done. Obviously, they know that there were fundamental flaws. But at this point, based on their constitutional rule, based on their position, all they did was to weigh the pros and cons, which one outweighs each other, then let's follow it. It doesn't mean that tomorrow this may remain the law. I can assure you that so far as Nigeria is concerned, so far as our electoral processes are concerned, if things are not tidied up, we'll see this situation again. What do? They can use that decision to correct whatever they have discovered wrong in this. But with the way it is, as at today, for me as a practicing lawyer, I prefer that we maintain this status because they've already been exposed to whatever. We've seen the height of it, having given that decision, whether per inquiry or not. But if they open up this other vista, then there will be crisis, there will be problems.
So it is your sense that this was a political rather than a legal decision?
Well, in political matters, there are a lot of considerations, of which primarily we consider justice. But when you talk about justice, just like Oputa said it, even in a criminal matter, it means that this is justice to all. Yes, as litigants, there's nothing that will make all of us be on the same page or all agree with the law. It's never done anywhere where a court will give its decision and both parties will applaud it. It's never done. Somebody must go rejoicing, the other person must, go angry.
They say the thrill of victory and the agony of defeat.
Exactly, sir. So going by that, and looking at these issues, for what has happened today, personally, I believe that even if there is merit, the Supreme Court on the altar of jurisdiction will knock it out. That's my personal conviction. And that's why I've not been talking much about it. It's just like seeing something in a glass, you're admiring it, but you can't touch it. That's exactly what has happened. And when you look at it legally, under the Constitution, the Supreme Court is supposed to be the court of final arbiter, and that they have exercised on the 14th.
Right.
Of
so
February.
in the first decision, that should have been final.
That should have been final.
Right.
Yes, because we have seen these other aspects. Now, can you say under the law that, given that there is room for review, do they actually come strictly under that?
Yeah, but what you're suggesting is that in some ways the law and the courts as the hope of the ordinary man and woman, that court cannot change what is, if there is an ineluctable proof that it has gone the wrong way in terms of delivering that justice that you're talking about. What you're suggesting is that the court would rather save face than deliver justice.
Now, the court in this instance, the Supreme Court, because of its position, that's what I said. And for us, ordinarily, looking at the issue as it is, ordinarily, without any further consideration, I may go with Justice Nweze. I said that earlier. But it's not enough just to suit what we think is the law. The law is also what Supreme Court says is the law. So, like in this case, what they did for me is to look at this. Does this actually qualify for a review? And if you say it qualifies for a review, why should it affect the holding? That is where I might differ from Ihedioha's lawyers. Because this ordinarily, if it will affect the holding this bad, it means that you are calling on the Supreme Court to now sit on appeal over their judgment, which is not contemplated under our constitution, which is not also the intention of the makers of
But there's precedent for that sort of review, isn't there?
Well, most of the precedents people cite, look at them very well. Most of them are under the slip rule. It didn't substantially affect the holding.
Right,
in
okay,
that same
I see the
case.
point you're making. But you mentioned precedent, which is obviously enormously important. How huge are the implications of the Supreme Court ruling as far as precedent is concerned? How scathing is the verdict going forward?
Well, I believe that, yes, looking at it, it might, on the face of it, be very difficult for my Lord Justices and Judges of the lower courts. That's the truth. But no two cases are the same. If they know what the law is, if they know what the preponderance of intention, legal principle, and precedents are, I can assure you as a lawyer that there is no precedent that doesn't have the opposite. There is none. So it's left for them, even in Supreme Court.
But as a lawyer who's a well-respected member of the legal community, are you appalled, as some lawyers have suggested? I mean, you saw the man in the clip from the court there. Are you appalled that the Supreme Court made this decision? And I'm not trying to take sides because that's not my job, but are you appalled that it has interpreted the law in the way that it has, in such a way as to raise the hackles of so many legal people like yourself who are saying, well, this completely undermines the rule of law?
I would rather call for restraint on my learned friends. This is our Supreme Court. That is the only firm we have, and that is the firm that is holding this country. Without the rule of law, there's no nation. And for the Supreme Court, their duty is to interpret that law, not my duty or any of the lawyers. Our duty is to present our position to the court and let the court decide. So for me, I would rather call for constraint or restraint on our utterances, on how we castigate this issue. Because if it's in our hands to do, they would have called on us to do it. But now that they are the ones doing it, this is their time. All we need to do, this is over.
Yeah,
Whether
but
it's
does it raise questions about the capacity of the Supreme Court?
That's the point I'm making.
Yes.
I may not want to sit down here and judge them.
Yes, I understand.
Yes,
It's a little bit difficult
yes,
for
it's
you
a bit
in those
difficult for me
circumstances.
to do that, irrespective of what I think or what I feel. But the issue is that no matter how I feel about it, it cannot change the situation as it is already.
Okay.
That's just my point.
Barrister Casimir Igwe, Managing Partner at Igwe and Igwe Attorneys, thank you very much indeed. You're watching the Arise interview. Plenty more still ahead as we continue to assess the implications of the Supreme Court ruling dismissing Emeka Ihedioha's application for a review of the judgment that sacked him as governor of Imo State. Stay with us. Welcome back to the Arise interview. I'm Charles Aniegolu. Now, as you may have heard, the Nigerian Supreme Court has delivered a landmark ruling and a hugely controversial one. It's dismissed the petition filed by Emeka Ihedioha, the immediate past governor of the southeastern state of Imo, who had asked for a review of the Supreme Court decision that ousted him. It's a judgment that will not be universally welcomed and is likely to further divide Imo State and the rest of Nigeria along political lines. But at least there was a dissenting opinion amongst the justices. Sentus Weze took the view that the court has an inherent responsibility to redeem itself and that the notion of legal certainty does not and cannot extinguish that capacity. Let's take a listen to more reaction outside the Supreme Court following this judgment.
The issue of governorship election dispute with regard to that concern Imo State has been put to finality as far the earlier decision of the Supreme Court, which the Commission has taken step to execute. The Commission obeyed with the decision of the Supreme Court to issue certificate of return to Hope Uzodinma, which we did. And as far as we are concerned, today's ruling does not affect that decision. So as far as we're concerned, Hope still remains the governor of Imo State, and then as for the earlier decision, and to me, this ruling of today has put to rest any dispute with regard to who is the winner or the validity of the Imo State governorship election of 2019.
Setting aside the judgment of the Court of Appeal and the Trial Tribunal and declaring Hope Uzodinma as the governor of Imo State. Thereafter, there was an application to set aside the judgment. Today, Supreme Court has affirmed its decision that Hope Uzodinma was legitimately elected the governor of Imo State. It has refused the application to set aside its judgment as an abuse of court process. We want to appreciate the Supreme Court, and we also want to appreciate our colleagues on the other side. This is essence of having a court. Instead of resorting to violence or self-help, they have come before the court. The court has spoken twice that Uzodinma is the governor of Imo State. I want to appeal to everybody to go back and work with him.
Well, for the reaction to all that, I'm joined now in the studio by the former presidential political advisor, Ahmed Gulak, who supervised the APC party nomination panel that selected Hope Uzodinma as the Imo State governorship candidate, and by Dr. Oke Ikechukwu, who is a public communications expert and executive director of Development Specs Academy. He's also a leadership and governance consultant. Thank you very much indeed for coming in. Let me get your reaction first of all to today's decision. Some have said that this ruling strikes at the very heart of Nigeria's democracy itself. What's your take on that?
Well, first, it's not the only thing that has struck at the heart of Nigeria's democracy. That heart has taken a lot of beating, so let's not bother ourselves with that. Also, on the matter of the judgment, anything anybody says now will be a matter of opinion and preference. I'm more concerned about the social reality and real politics. And I'll take it from the background that when the initial judgment came, what was Ihedioha's response? He gave a very statesmanly address to his people, calling for order, saying he's surprised that he doesn't think this is fair. But what I saw was a man who showed he was a leader, who did not indicate anything personal against either the APC or the newly declared governor. And that, for me, my entry on this conversation, you say that as a first trajectory, namely that Imo stands to gain nothing if there is sort of violence, because Emeka will not lead that violence. He's a leader. The second thing then is to look at, okay, the judgment has come. How do they feel? How do I feel? I'd written about this matter on the back page of this day, I think a week or two ago. My position on that was clear, that the Supreme Court it's the judiciary that declares that this law is law. It's the judiciary that says this provision of the Constitution, this is what we think about it, it should subsist or that it shouldn't. So to that extent, I hold the view that the judiciary, not being the Almighty himself, being human, is capable of if you like, reversing itself, especially where it could be suggested or suspected or indicated that there has been misleading proceedings.
Well, there is a suggestion of political corruption here, basically, at that court. I mean, not the court itself, but the materials, the issues
very
that were
tendered
brought
on
before
the basis
the
of
court.
which the judgment was made. All of the material is open to argument. The question of whether you can have outcomes that there are 3 of us in the studio, and we see in the refreshment provided that you make provision for 7 people. You have to explain that. All of that is in the mix. But like I said earlier, and I'll repeat, that judgment for me is not pleasant news. But I also know that in other crimes, in fact, I was watching the documentary, was it 5 days ago, of a US case. 3 young men were jailed for raping and murdering a girl. 20 years later, the actual culprit was found through DNA processes. And the court actually was not in the process of getting those involved in that wrong, and the rest of it. So this, for me, is a landmark case that provides part of what will become the building blocks for strengthening our judiciary subsequently. So is this a pleasant outcome? Not for me. Is it? Did I think it should be resolved? Yes, I thought so. But being that a verdict has been given, to go out of it and pretend that the Supreme Court is not the Supreme Court, there's no outcome other than disorder, and that doesn't work for me.
Okay, let me bring you in, Ahmed Gulak, because quite a number of people who are on the other side of the fence have said that they've argued vociferously that the Supreme Court did the right thing. Where do you stand on that?
Well, speaking as a lawyer, I always believe that the Supreme Court judgment is final. And don't forget, under our laws, there are provisions where you can apply for the Supreme Court to review its decision.
Which is what was
Review is not setting aside the judgment.
Right.
There are conditions, 3 conditions. 1, if there are typographical errors, if there are accidental slip that can change the meaning of the judgment. This is number 2. The 3rd one is if the judgment was obtained by fraud. These are the 3 conditions that you can approach the court and say, review your own decision.
So that was part of the basis for the approach. There was a suggestion of political corruption, of fraud.
No, there wasn't. Everything was placed before the 3 tiers of courts that had this case, from trial tribunal to the Court of Appeal to the Supreme Court. All cases were put before the court. The issue in contention was the 388 unit results that APC and their candidate Hope Uzodinma said, look, INEC had no right under our laws to exclude these 388 units. The 388 units, before they were tendered and accepted in evidence, they were heated debate from both sides, from lawyers of the both sides. They were heated debates. And at the end of the day, even the trial tribunal admitted it in evidence and said that at the Court of Appeal, although the Court of Appeal ruled that the petition had no merit, but they did not say that they were inadmissible. It is the issue of the 388 unit result that is the contention here.
Yes, absolutely.
Added, Hope won the election overwhelmingly. That is the contention. And don't forget, some people who are not lawyers don't understand the processes of law. Once you file a petition in court, you settle pleadings. What did you say? What are your claims? And as a defendant, not only will you respond to these claims, if there are issues that you also have, disagree with it, you file it as either a counterclaim or a counter petition. So once you file your petition and the respondent responds, issues are joined. You don't bring in other issues that you did not settle.
Yeah,
from day one.
particularly at the Supreme Court level.
At the Supreme Court now, we are now talking about Supreme Court judgment. The Supreme Court justices unanimously, 7 justices of the Supreme Court, held that the 388 units results, INEC had no right to exclude it.
Okay,
and now the Supreme Court finally decided that Hope Uzodinma, with his results ab initio, has won the election.
Okay. You made that point. Let me just bring in Dr. Oke Ikechukwu, because we've still got more time, so don't worry, you'll have a lot of time to talk. Let me bring him in, because the point here is, as he said, it's those polling units, those votes that were brought in, which, from my understanding, were declared invalid by the Electoral Commission, which has a right to make such a declaration.
Yes, for me, the votes had what you might call an integrity deficit.
Yes.
And therefore were not accepted. And even if you grant the fact that they were in the end accepted, you have not resolved the matter of how you could have more votes than accredited voters, and how the outcome will lean so conspicuously in favor of a particular candidate and tendered by the police. But you see, those are issues of law. And as he has said, there's a letter of the law, and when some of the proceedings, you see the way it's gone, it might be difficult to engage outside the law. But that's why jurisprudence stands as the elder brother of practiced law. And it is within the domain of jurisprudence that you speak more seriously as a statesman, and from the standpoint of natural justice, equity, and good conscience. And it is in the context of that that we then would ask a number of questions pertaining to the outcome. And those are the issues of what kind of president is it?
Absolutely.
That I won an election to become chairman of my club by 10 people voting for me, but the club had a total membership of 6. That's the thing. And so from the standpoint too of equity and good conscience, and now it's purely personal, my mom was the patron, the matron.
I'm going to have to ask you to hold that thought, because when you bring your mom in, it's going to be a long story. But don't worry about it. Don't worry about it. We'll come straight back to you, because we took the words away from you. We've got to take a break. You're watching the Arise interview. Plenty more still ahead as we continue to assess the implications of the Supreme Court ruling dismissing Emeka Ihedioha's application for a review of the judgment that sacked him as governor of Imo State. Stay with us. Welcome back to the Arise interview. I'm Charles Aniagolu. Now, if there is one Supreme Court decision that will at once become both famous and controversial, it would have to be this one. The Nigerian Supreme Court dismissing the application for a review of its decision to sack the former governor of Imo State, Emeka Ihedioha, and declaring Hope Uzodinma the winner of the ballot. It's a decision that's irreversible, and it's delivered the crown of Imo State to Hope Uzodinma, crushing the hopes of millions in the southeast who pitched their tent with Emeka Ihedioha. It's a case that will most probably result in new interpretations or even a new legal concept altogether, and will most certainly affect, for better or worse, Nigeria's confidence in the Supreme Court as an impartial guardian of the rule of law. Well, with me in the studio, the former presidential political advisor Ahmed Gulak, who supervised the APC party nomination panel that selected Hope Uzodinma as the Imo State governorship candidate, and by Dr. Oke Ikechukwu, who is a public communications expert and executive director of Development Specs Academy. He's also a leadership and governance consultant. Thank you very much indeed for staying with us, and we come straight back to you because you were telling us a jolly interesting story about your mother.
Yes, she was a matron of one of the young ladies club, the Mary League. She passed on, and so in the matter of the burial, the group came and that there's this amount you have to pay for them to attend the funeral. I said, it's not possible. She was your matron. She's bringing you up as your mother. You pick the wrong principles when you go. They said, no, it's in their constitution. That the priest could confirm it. I went to the priest and told him, you have a higher duty to these children than this constitution. Go and rewrite it. You bring up a mercenary younger generation when you put conditions like this, etc., etc. What am I leading up to with that? In the matter of social responsibility, there are moments when the letter needs to be reviewed. For me, this is one of those instances where the learned justices could have, and there were technical grounds that could have made it possible. But like I said earlier, since they didn't choose that path, I will not join in maligning, because judiciaries in all countries, particularly the United States, have massive frauds that was part of their history, massive human errors, massive technical, what you might call technical details that led to certain judgments. So since this is a nation in evolution, some people ask, there are enough angry people already, so let them enjoy and display their...
But nevertheless,
Yes.
if the emperor is not wearing any clothes, we can't pretend that he's,
No,
he's
you can't.
wearing
You have
clothes.
to say he's not.
I mean, does this, in your assessment, undermine the integrity of not only the court, if it's clearly made a decision that allows a form of political corruption to become entrenched, to become part of its precedent and so on? Does it undermine the integrity of not only the court but elected institutions in Nigeria?
I would say yes and no. It creates perception challenges. It creates the suspicion of absence of neutrality, but these remain perceptions and suspicions. And the facts, as I see them, I've told you what kind of interpretation I would have preferred. But to infer from me that the Nigerian judiciary stands fundamentally diminished would be to be unfair to the lawyers and justices and judges we know all over the country. This case, yes, it is. There are issues to be raised about it. But does it characterize the Nigerian judiciary as an institution, as a fundamentally fraudulent platform? The answer is no. So let's separate episodes from the identity of institutions. This is annoying to a lot of people. That's why I say there are enough angry people. Please let them not step down on their anger. Those who are celebrating it, be in your camp, but that's how evolution occurs.
Right.
In politics.
Well, let me bring Ahmed Gulak in, because, I mean, in to some extent agreeing with what you said earlier, obviously there has to come a point where litigation is brought to an end. And we're clearly now at that point with regard to Imo State.
We are at that point. To me, we ought to have cleared the hurdle since on January 14th, because the Supreme Court, under our laws, you know, you don't administer laws according to your whims and caprices. The laws are there. When you go to court, there are procedures you have to follow. Ordinary people may not understand. But the question is, we have reached the final boss.
Yeah, but you're a lawyer yourself.
Yes, I am.
Is it your sense that the Emeka Ihedioha's application for a Supreme Court review had merit and is supported by facts and figures?
To me, it had no merit, and the Supreme Court justices confirmed it lacked merit. In fact, it is unbecoming of the political class to be dragging our judiciary to Market Square, to prayer grounds, and all what have no God. So the issue is, we have reached the final bus stop. Let us wait. Emeka Ihedioha and the PDP should go and prepare for 2023 or 2024. Let Hope Uzodinma be in charge of Imo State and govern them. What we expect of him is to give the people dividends of democracy. He must show himself to be equal to the tax. He must justify the confidence reposed in him by Nigerians at the polls, because from day one, he won the election. He must justify the confidence reposed in him by Imo people. He must go there and work, and let him not be carried by the euphoria of victory. What we, in the political class, fail to understand is that today you may be there, and it's not going to last forever. Somebody else will come tomorrow. All we need is all hands should be on deck to see to it that Nigerians are taken out of the woods. We have a lot of challenges. Distractions should not be part of us. To me, today's Supreme Court judgment vindicates my stand as a lawyer, vindicates the people from the other camp that they said, yes, they won the election, and the Supreme Court on the 14th of January confirmed that Hope Uzodinma won this election.
Okay, let me
we should
bring
not be
Dr.
going forth.
Right, I understand all that, but what we're doing is analysis
Yeah.
now, after the fact. As you have said, and as Dr. Ikechukwu has said, we can't change the Supreme Court's verdict. But Dr. Ikechukwu, do you see the Supreme Court decision beyond your own sense of, let's leave it be and, let's sort of get the, keep the institution ticking along sort of thing? Do you see this as motivated by a connection to the government of the day?
That's the allegation. That's part of the perception. I have no basis for affirming or denying it because it's a rumor. That's why I felt I had hoped they would reverse the judgment, because since there was that suspicion already that it would have given substantial positive markup to the other image of the. But since it hasn't happened, this is the reality. But beyond that, and I'll repeat the point I'm making, human beings are fallible. Fallibility is a fact of life. And the fact that there is a constitution that has this provision provides the opportunity for you to say, read the provision and indicate in its presuppositions the absence of error and in a higher duty to humanity. This is our perception. Even in law and jurisprudence, Lon Fuller, what was his case? There was a hypothetical case. Some guys got stranded in a mountainous area. I think their plane crashed, and they were about to starve to death. So somebody, one out of the 7 or so, suggested, look, instead of all of us dying, let's kill one of us and feed on the person.
A movie was made.
Yes, you know that in the end, the person who suggested was the one who was killed. But when they got out, it's slightly different from the movie story, the Lon Fuller example. The matter was taken to court. Everybody, it was voted on. This was democracy, majority vote. And the judge said, that stone that separated you from the sun, does it separate you from humanity? The answer was no. He said, then cannibalism is wrong. So that's a kind of majestic intervention one had hoped for, but not seeing it. That is not the reason for Imo people to oppose or work against.
But would it have been an example of judicial activism if the Supreme Court had gone the way of Emeka Ihedioha? And judicial activism is not something you associate with Supreme Courts generally speaking.
Yes, but you associate judicial statesmanship and transcendence with the Supreme Court and justices of Supreme Courts. And that's the angle one I was looking at it from. But to go from there to actually now go maligning them, it doesn't work for me. It's as simple as that.
So, Ahmed Gulak, surely, I mean, we would have been nuts if we thought the Supreme Court would come out and publicly acknowledge that a considered ruling delivered unanimously by 7 justices was flawed. I mean, just on the basis, just as a personal admission, coming out to say, hey, we're 7 Supreme Court justices and we screwed up.
Well, like you are saying, we are analyzing situations.
Yes, that's it. We're doing analysis, because
analysis
there's nothing we can do now about the verdict.
Nothing anybody can do.
Yes.
But what pisses me off is from some quarters associating the decisions of Supreme Court or any court with the government in place. It's very wrong. If you say that, what happened in Barrister? APC won that election. Clear. And APC is the ruling party at the center. And yet the Supreme Court gave the decision they gave. I believe, and every Nigerian, I plead with all Nigerians to believe in the sanctity of the Supreme Court, the neutrality of the Supreme Court.
Right, let me comment on
And,
that. Sure.
you know, some perception, we bring it upon ourselves through rumor milling, rumor mongering, multiplier rumors. We bring this, disrepute to ourselves,
Okay, let me bring him in,
to
'cause
our
we've got
nation.
about a minute before we take a break. Let me bring him in to respond to
yes. On the bio, no, just to back up a
Right.
point that's often overlooked, the criticism of the judiciary as pro-government. The fact that, think of the Zamfara State judgment, the one on Rivers State, and then recently APC. You see, PDP has demonstrated impressive incompetence in its own storytelling. By always saying Atiku judgment because they were, but Atiku came after successive anti-APC judgments. So rather than devise what you might call a rational explanation for any suggestion of partiality, you keep doing press releases. It shows an incompetent opposition that is incapable of holding itself together. I thought that point needed to be made. And that's why I'm reluctant to get into the mix of saying to say anything about the Supreme Court justices, because the sustained interventions of the politicians, particularly of the opposition, has created a situation where comments about the judiciary can no longer be taken seriously because most of the time they are tendentious. And you don't muddy the water. You just, why is it that they're so angry? APC just occurred. Before the election, an entire state was wiped out, Zamfara. Right. Nobody said PDP was paying it. So that level of objectivity, I'll prefer to insist on it.
Okay, we're going to take a break. We'll be back in a hot second. You're watching the Arise interview. Plenty more still ahead as we continue our analysis of the Supreme Court ruling dismissing Emeka Ihedioha's application for a review of the judgment that sacked him as governor of Imo State. Stay with us. Welcome back to the Arise interview. I'm Charles Onyegolu. The final irreversible decision of the Nigerian Supreme Court is in, and it's delivered a favorable verdict for Hope Uzodinma, who can now rest easy in his claim of the governorship crown in Imo State. The judgment, though, was split 6-1, with the majority of justices, led by the Chief Justice, Tanko Mohammed, ruling that the court lacks the jurisdiction to sit on appeal over its own judgment, and that Mr. Ihedioha's petition lacked merit and was therefore summarily dismissed, but with one dissenting opinion. It's a Supreme Court decision that some legal analysts are already saying will go down in history as one of the court's most ill-conceived judgments. They say that in issuing what they see as a poorly reasoned ruling, the Supreme Court has unnecessarily exposed itself to charges of partisanship and risks undermining its stature as an independent, impartial arbiter of the law. Not everyone, though, agrees with that assessment, and many have commended the Supreme Court for its decision. With me in the studio, the former presidential political advisor, Ahmed Gulak, who supervised the APC party nomination panel that selected Hope Uzodinma as the Imo State governorship candidate, and Dr. Ike Ikechukwu, who is a public communications expert and executive director of Development Specs Academy. He's also a leadership and governance consultant. Thank you for staying with us. And you were making a point before we took a break. You were talking about the fact that the Supreme Court had decided, if you like, in the context of political decisions, in favor of the PDP in Bayelsa State, and now in favor of the APC in Imo State.
Yeah, I would say that we should just keep a few things on the table, namely that whenever the Supreme Court decides in favor of one case or another, it does not necessarily translate into partiality, but it might actually be a case of partiality. And for me, as a person in the case of the Ihedioha case, I would have preferred a judgment than the current outcome. And to that extent, if you ask, oh, okay, are you happy with this? I would say no. But if you then say, let's encourage people to insult the Supreme Court, I say that's not how I grew up. If you say more people should be mobilized against Hope Uzodinma, I'll ask them, which other governor are you going to have? Emeka started some fantastic developmental projects. If Hope Key is into it, carries the people along with him, what's going to happen? It will be to prepare for the next election. But that's different from saying, unfeelingly, oh, let them go and prepare. No. Imo State needs to survive. And that cannot happen in a state of disorder. And so the people need to cut their losses, do a re-evaluation, plan a re-engagement template. But it's important that the massive human capital of that state is not violated. Hope has a greater incentive now than anyone else because perception, his score is very poor. In terms of political rating, we know the results. We know the percentage of actual voting. You can't say that, oh, the masses are dancing for him. That being the case, he has a duty to reverse that perception. But more importantly, to show that he's concerned about
Imo. That's actually the same point he was
He's concerned about Imo.
Which is true.
And therefore, if people see a continuity in the kind of community-based development and carrying people along that Emeka brought on, Hope will have a wider team.
But you know that there was a lot of international focus on this case,
yes,
which was what made it so interesting and so just beyond the sort of the bounds of Nigeria alone. I mean, and all the people internationally, including lawyers and all that sort of thing, seemed to think, having studied the case, that the Supreme Court had erred.
I share that view. I've made no apologies about that.
So what I'm wondering is, beyond the fact that we want everything to be shipshape and seaworthy as we go forward, I mean, is this likely to hurt the Supreme Court more than redeem it? Is its image tarnished by this, bearing in mind that there are people who agree with its ruling, but possibly as many who disagree?
My perception is that it will impact to some extent, because we already the disposition of, if you like, the international observers was apparent. The expected outcome from that side was also apparent. Right. So naturally, it's likely to then incline them to say, well, you see, they've done what they like. But whether that will translate into an annulment, whether it will translate any other thing, into anything, is another matter. And in this, and this is not being mischievous, we must begin to advise ourselves on the extent to which international community, quote unquote, is part of our conversation. Not with reference to this matter, but our own integrity as a people should derive from our own engagements. Now, there's some perception, and I share the perception that this outcome should have gone the other way. But am I a justice of the Supreme Court? No. Will it make me not to say I'm not happy about it? No. Society must develop.
Yes. You have a point. So let me bring Ahmed Gulak in. I'm going to ask you, Mr. Gulak, you were wearing your legal hat sometime just a few minutes ago. Now wear your political hat. In terms of sowing and deepening the political divisions within Imo State in particular and Nigeria in general, has the cleft or the chasm deepened and the fissure now wider than ever before in terms of political divisions in this country as a result of this case?
I don't believe so. Let me take it from the international community angle.
Right.
One, after this judgment, the PDP, in its characteristic manner, staged a protest to UN embassy, to American embassy, to UK embassy against the decision of the Supreme Court. That is in the first instance, which I condemned, and every Nigerian should condemn. We are an independent country, although we are not an island to ourselves. Coming to whether this judgment will deepen division or bring people together, I say it all depends on how the incumbent governor, Hope Uzodinma, carries himself in that state. We are all politicians. Politics is about service to the people. That is in court to some. If Hope Uzodinma...
That's in theory.
It's a theory. Hope Uzodinma, as a governor, and the way I know him,
right,
makes himself available to the people, brings people together. All hands should be on deck, makes an open door policy. He is now a governor of the people of Imo State, not APC, not ABGA, not PDP. Every indigene of Imo State, including visitors to Imo State, are people he governs, are people he's going to provide services for. If he does that, there will be no division. If he fails in doing that, the division may continue along either party lines or zonal lines. Because in Imo State, there are 3 zones. The Olu zone, where Hope comes from, the Ekubwe zone, and the Uwere zone. So these are zones. And you know, Okorocha was from Olu zone. He spent 8 years. And now Hope Uzodinma is the same from Olu zone. That is where the sentiment is coming from. I think you understand. So as a governor, he should bring everybody together. Not only the zones, but all the local governments. He should touch them in development. And if he does that, I can assure you, Imo is going to be Hope, and Hope is going to be Imo.
Because of course, Hope Uzodinma is coming on the back of an APC that, first of all, is not very popular in the southeast, but particularly in Imo State, has a rather bad reputation.
Very, and substantially nurtured by the immediate past, the governor before Emeka, who took governorship and leadership straight into the rat hole in hell.
Which is why, for some people, it's inconceivable that the APC would actually win elections.
So even if he stood a good chance,
right,
the performance of that governor was against it. Then Emeka's appeal was another strong element. and we saw the outcome. But having said that, the situation on the table presents a major integrity perception crisis that needs to be addressed. If somebody thinks I am not doing well, and I've been given an opportunity to perform, I'll have to ensure that I do well. But more importantly, I'll have to show, because I recall clips of Emeka's victory. The night celebrating the election results, I saw him and Hope hugging themselves and laughing. It was a national.
Not the correct video.
You know, so
like
okay,
that.
no,
Well,
it was at the reception.
that's
correct.
a discussion
That's
for
correct.
another
No,
day.
it's a different
We've
discussion.
literally got 30
It was
seconds.
a different scenario.
Now, in a matter of your 30 seconds, what one has to say is that the judgment is in place. It has, for some people, strengthened the perception crisis of the Supreme Court. It has, for others, led to a simple affirmation of the letter of the law, not the spirit of jurisprudence, and that's a reality we have to contend with. And that's a reality which, in spite of it, IMO must move forward.
Okay, Dr. Oke Ikechukwu and Ahmed Gulek, thank you very much indeed to both of you. That's it for this edition of the Arise interview. Join us again tomorrow. From me and the entire team here in Abuja, bye-bye, and thank you for watching. Brilliant.